Hello, I'm Debojit Das and welcome to Courts Today by LiveLaw, your daily summary of the top legal developments from across the country. Today, India's courts addressed a diverse docket dealing with crucial issues. So, let's begin. Where else to start from, as the infamous advocate Rakesh Dwiwedi's actions have consequently reached the legal stage of initiating criminal contempt. This action addresses the advocate's severe violation in court violence coupled with unrepentant fundamentalist media statements, which is considered a malicious attempt to scandalize the court and undermine public confidence in the judiciary. When this advocate committed the act of throwing a shoe at the Chief Justice of India, and because the Chief Justice demonstrated restraint by declining to press charges personally, the responsibility to pursue the matter now falls upon the legal fraternity. To initiate a criminal contempt, citizens must first obtain the mandatory consent of the Attorney General of India, as required under Section 15 of the Contempt of Courts Act. Lawyers have formally sought this consent, arguing that the advocate's behavior clearly demonstrates a deliberate effort to obstruct justice. The Attorney General's decision acts as the legal requirement. If consent is granted, the Supreme Court can formally prosecute the offender. The prosecution is essential to reaffirm that courts are secular institutions and that judicial integrity must be aggressively protected from politically or religiously motivated intimidation. Moving on to a noteworthy judgment, and some might say a timely judgment, which answered this question. If you're caught at the wrong place at the wrong time during a chaotic incident, are you automatically guilty? The Supreme Court just drew a critical line between a curious bystander and being a criminal. The case Zainal versus the state of Bihar involved a violent community clash from 1988, where 10 individuals were convicted simply for being present at the scene. The Supreme Court took a deep dive into Section 149 of the Indian Penal Code, which deals with membership in an unlawful assembly. Acquitting the accused, the bench, led by Justice J.B. Pardiwala, clarified the law with a powerful ruling. And I quote, "Mere presence at the scene does not ipso facto render a person a member of the unlawful assembly." The judges emphasized that liability shifts to a person only when they actively shared the common object of the mob. They laid down a crucial rule of caution. In large mob cases, evidence must be scrutinized with utmost care to avoid punishing passive onlookers. This means courts cannot rely on vague general allegations. They must instead look for concrete, credible material, like the individual's conduct, the weapons they carried, and any overt act that proves their shared intent to participate in the crime. It's a vital judgment protecting innocent citizens caught in chaotic situations. Next, we saw the Supreme Court today delivering a critical verdict, acquitting Dashwant, the Chennai man previously sentenced to death for the 2017 rape and murder of a 7-year-old girl. This reversal highlights the absolute necessity of an unbroken chain of evidence in criminal law. Dashwant was convicted by the trial court, a decision upheld by the Madras High Court, primarily based on circumstantial evidence. However, the Supreme Court, through a bench of Justices Vikram Nath, Sanjay Karol, and Sandeep Mehta, found the prosecution's case had fatal flaws. Crucially, the court held that the prosecution miserably failed to prove the vital circumstances. Specifically, the court found significant inconsistencies and loopholes in 3 key areas. Number 1, the last seen together theory. Claimed that the accused was the last person seen with the victim. It was contradicted and found unreliable. 2. The forensic evidence, including the FSL report and the CCTV footage intended to link Dashwant to the crime, was marred by serious inconsistencies and procedural loopholes. And number 3, the confessional disclosure statement was also deemed unsafe to rely upon. The court emphasized that where a case rests entirely on circumstantial evidence, every link in the chain must be conclusively established, leaving no room for doubt. Given the prosecution's failure to meet this high standard, the court set aside the conviction and death sentence, ordering Dashwant's immediate release if he is not wanted in any other case. This judgment serves as a powerful reminder of the principle that justice must not only be served but also be based on unimpeachable proof. Staying with the Supreme Court with this one too, as some sharp observations were made by the top court regarding the United Nations High Commissioner for Refugees, or UNHCR, issuing refugee cards to foreigners in India. The comments came while a bench of Justices Suryakant and Joy Malia Bagchi was hearing a plea from a Sudanese national seeking interim protection from deportation who claimed to hold a UNHCR-issued refugee card. Senior counsel argued that the Ministry of Home Affairs gives weight to these cards. Responding directly to this point, Justice Suryakant made the critical remark, and I quote, "They have opened a showroom here and they are issuing certificates. We don't want to comment on them." Justice Bakshi further clarified the legal position, noting that India is not a signatory to the 1951 UN Refugee Convention. This means that having a UNHCR card does not confer enforceable rights under India's domestic laws. The court declined to grant interim protection but noted that the petitioner's case was already being considered by the National Human Rights Commission, disposing of the plea with the suggestion to seek further directions there. Interestingly, the Supreme Court emphasized the need to be very careful, noting that lakhs and lakhs are sitting here overstaying. Taking a look at Uttar Pradesh, as the Allahabad High Court today issued a scathing critique, pointing the finger at what it calls the poor quality of assistance from many advocates, labeling it a very sad state of affairs. In a major observation, Justice Subhash Vidyarthi noted that this lack of preparation and diligence by lawyers acts as a direct hurdle in speedy dispensation of justice. This is critical because the Supreme Court of India has mandated that all bail applications must be decided within 2 months of filing. The High Court stressed that when lawyers present documents in a haphazard manner and fail to assist the bench effectively, even after being given time to correct mistakes, it actively thwarts this 2-month deadline. The court highlighted its overwhelming workload, citing a roster that includes everything from 91 fresh matters to all minor bail and anticipatory bail cases, noting that all proceedings must be handled within a fixed sitting time. The order emphasized that advocates are officers of the court, not just client representatives, and their unprofessional conduct delays justice for ordinary litigants, especially in critical cases like maintenance pleas, which must be decided expeditiously. The High Court's message is as clear as it could be. The judicial system's limited resources demand fair, precise, and professional cooperation from the bar to ensure timely justice is delivered. From one end of the country to another, as the Kerala High Court sharply criticized the union government's stance on providing financial relief to the victims of the devastating Wayanad landslides. When the centre argued it was legally restricted to offering only loan restructuring, citing a 2025 amendment that removed the loan waiver recommendation power, that is Section 13 of the Disaster Management Act, the division bench of Justices A.K. Jayashankaran Nambiar and Jobin Sebastian vehemently rejected the defense. The judges asserted the government's position was merely an unwillingness to act and an attempt to hide behind the legal provision. They condemned the inaction as a complete abdication of responsibility by the chief executive of a welfare state, stating emphatically that the union had failed the people and that the victims deserved dignity, not charity. The court intervened, warning the centre against such a stepmotherly attitude. Next, we saw the Delhi High Court taking a stern look at a highly controversial notification issued by the Staff Selection Commission, or SSC. The issue here: a complete ban on candidates, coaching institutes, and social media platforms from discussing, analyzing, or even circulating question papers after an SSC exam has already been conducted. The SSC issued this notice warning of strict penal action against newly implemented Public Examinations Prevention of Unfair Means Act 2024. The intent of this law is to curb paper leaks and organized cheating. However, the SSC extended the law to prohibit even post-exam discussions. Penalties under this act are severe, including potential jail time of up to 5 years and heavy fines. A public interest litigation, or PIL, was filed challenging this sweeping ban. The petitioner argued that prohibiting discussion of a paper after it's over is an unreasonable restriction that directly infringes upon the fundamental right to freedom of speech and expression guaranteed under Article 19 of the Constitution. They contended that post-exam discussion helps aspirants, educators, and peer learning groups. During the proceedings, the division bench of Chief Justice D.K. Upadhyay and Justice Tushar Rao Gadela shared the same skepticism. The Chief Justice remarked, "You cannot put such gag orders. What is it about question papers that you cannot discuss?" He highlighted that discussing exam papers is a common, harmless practice, a first step after leaving the examination hall. The Delhi High Court has now issued a formal notice demanding a response from the Union of India and the SSC on how they legally justify this gag order. The core question remains: does a law meant to prevent unfair means also have the power to stifle academic and public discussion? The matter is set for further hearing in November. Shifting our focus to the Madras High Court that closed the plea filed by Sub-Inspector Priyanka Yashini, who challenged the Central Adoption Resource Authority's rejection of her adoption application. Justice M. Dhandapani noted that while the petitioner argued that the denial amounted to discrimination and violated the Juvenile Justice Act, the existing adoption regulation of 2017 does not currently include provisions for adoption by transgender persons. The regulation only permits adoption by a couple, a single female, or a single man. Since the High Court cannot issue a direction that contradicts the current regulations, the court disposed of the plea. Instead, the court directed Priyanka Yashini to file an application with the Union Ministry of Women and Child Development to seek an amendment to Regulation 5 of the Adoption Regulations, which would formally enable transgender persons to adopt through the CARA agency. The ministry was ordered to consider this application and pass orders within 12 weeks. And for our final stop, we take a look at the Bombay High Court as it adjourned the hearing on a plea by actress Shilpa Shetty and her husband, businessman Kundra, seeking permission to travel to Los Angeles and other foreign destinations for business and personal trips. The couple is seeking to quash a lookout circular or LOC issued against them in connection with an FIR alleging a 60 crore rupee fraud. A businessman, Deepak Kothari, claims the couple conspired to cheat him, misusing funds meant for business expansion for personal expenses between the years 2015 and 2023. A division bench led by Chief Justice Shri Chandrasekhar directed the couple to deposit the entire alleged fraud amount of 60 crore rupees with the court if they want their foreign travel request considered. Chief Justice Chandrasekhar explicitly stated, and I quote, "You deposit the entire amount in this court and we will consider the request then." The complainant's counsel raised an apprehension that the applicants, being foreign nationals, might not return to India. The court noted that the couple was not arrested in the case only because of their cooperation with the probe agency. The judges also sought verification details for a proposed event in Los Angeles that Shetty was scheduled to attend. The court has adjourned the matter for further hearing on October 14th. The couple must now decide whether to comply with the 60 crore rupee deposit condition to proceed with their travel plans. And that wraps up our segment for courts today, covering key decisions from the Bombay High Court, Delhi and Madras High Courts, and of course the Supreme Court. For complete details on all the judgments mentioned here and more, visit www.livelawmedia.pvt. I'm Devojit Das. Thank you for watching.